To Patriots Law Group Live. This is Legal Strategies for Military Divorce. We welcome everybody back today, and we're bringing you a great new topic. This is all about your military pension and how you can secure it. These are 5 must-have terms in a division order. And if you are a active service person, you are a veteran, or you're a military spouse, you are in the right place if you are navigating a military divorce right now, because we have 2 of the best legal experts in military divorce here with us today. We have Mike Lyons and Pat Hughes, who are going to be diving deep into this subject as we do every second and fourth Wednesday of the month during this live stream. And I want to bring them right here to the stage. I want to say hi to Mike and hi to Pat. Welcome.
Good to be here, Maureen.
Good to be here, Pat. I'm so glad you're here. Mike, unmute for a second. I know we've been doing the unmute and mute thing today. There you are.
There we go. Yeah. Thanks for having me, Maureen. Good to see you.
Welcome. I'm so glad. This is a very important topic when we're talking about finances, and we are talking about securing your future, especially in divorce. And we always do things in 5s around here. So I would like first, I know, Pat, you have a little bit of an introduction on this that you want to dive into. So you want to take it away on this subject?
I will, yeah. So military pension order is actually a pretty complex topic. And so there's many more things than just 5 that we probably could come up with, but the 5 key ones that we've identified are what we're going to talk about today, because when you submit an order from the court to the Defense Finance and Accounting Service, DFAS, if it doesn't contain the very specific information that DFAS requires, then it's going to get rejected, and then maybe potentially you have to go back to the court and get a new order issued, which is just adding to the time and expense of things if you don't get it right the first time. So I think that's kind of why we want to help identify what a number of the issues are that DFAS ends up rejecting an order for, that maybe that allows somebody to avoid those pitfalls in the future.
Yeah. Yeah, good point, Pat, because, these 5 that we're going to talk about are kind of the universal 5, and the most fact patterns, well, really all fact patterns require these 5, but there's then other elements in different fact patterns that are needed. So we do want to make sure we foot stomp that these are the big 5, not the only 5. So I'm going to jump in with the first one, Maureen, if you're okay with that.
Oh, absolutely. Take it away.
All right. Well, good. So the first thing that this order needs to have, and sort of to back up and give a little bit of background, once you get divorced, you're going to have a divorce decree. Here in Maryland, they call it a judgment of absolute divorce. That divorce decree, though, is not the order that DFAS is needing, and which will be used to divide a military pension. Rather, a separate and very specific order known as a military pension domestic relations order, or a constituted military pension division order. There's a couple of names they go by. And that's what we're talking about, is this post-judgment order that gets created so a military pension can be divided. And in this order, the very first thing that DFAS needs is they need to know who the parties are, right? They need to know who is the service member that they're going to take this retirement pay from. Who is the former spouse that they're going to give this retirement pay to, or a portion of it? Who is the court, right? Because the federal statute's very specific as to, who has, or what, I guess, has the authority to divide a military pension. So this order needs to expressly state all of these pieces of information. So DFAS, the military's accounting and payroll arm, can look at and say, okay, we have all of these specific details. We know exactly the court was the right one. These are the parties, and can get to work with it. The one thing that I'll note here is, the name, the address, and the social security number are all required by DFAS. That's so they know where to mail things, but then also so they can identify with the social security number who gets the taxes. You do not want to put in, and you should not put in, the social security number into that order that's submitted to the court, because it's public. And so there's a separate form that DFAS has that you would put that information in, so that way it's kept, private and secure. So that's the first thing you need to have in your military pension division order, is to clearly articulate the parties in the court proceeding, name, address, social security number, case number.
Do a lot of people make that mistake? I mean, you're talking about this being public, and so I think that's a word of caution there, right there, that don't put your social security number in there. Because you made that your tone went up a little bit, and you were kind of like, don't put that in. I'm gathering that that's a mistake a lot of people make.
Well, believe it or not, there's a template online that has a blank. The social security number is blank. The lawyers who do this generally don't. But if somebody tried to sort of DIY it, they may just say, oh, I need the social security number, put it in and submit it to the court. And maybe they don't even understand that somebody can come behind them and look at the court's file. They just assume I gave it to the clerk, and they're going to keep it safe. So.
Right. Great information. All right. So
and maybe another example of, you can't always trust what you find online. Right? As the Google machine doesn't always produce the best of forms, and more things are required than what those might provide, or maybe less than what's necessary to keep your information secure. A second thing, and we're, as Air Force guys, Mike and I we're used to the Air Force having checklists, and this is just one of those things where maybe some of the information that we're talking about today is intuitive and you would expect to be included, but if you don't account for them all, then you're not going to succeed. And so, for example, the order must clearly describe the marriage and the divorce proceedings. So you have to state in the order, when were the parties married? What is the date of the divorce? You have to include that the order is determining that as entered incident to the parties' divorce under the laws of the state of the order, that it's dividing the pension. And also that certain military retirement benefits have been found to be marital property. So all of those things need to be included in this order so that DFAS can accurately confirm that the court has made these determinations, and as a result is apportioning a piece of that military pension to the non-military spouse.
Yeah.
Often is that overlooked? I mean, we're talking about things that the average person, there is no way they know this. We're just at number 2, and I'm listening to this, and right. Google is not going to tell them this. Most people are going to miss this.
Yeah, I mean that's why we're bringing them up here. Right, Mike?
Exactly.
That's right. Yeah.
And like we said, these are sort of the universal elements of an order, and that's probably why they're so fundamental. And as it relates to that, the basket of information that Pat just mentioned, some of it gets overlooked because you just think this is an order from a client's perspective that I'm giving to the court. Well, the court knows who it is, and the court knows what its case number is, and the court knows who we are. And you may not intuitively think that it's an order, though, after the court passes it, somebody has to work with. Like, it has to be a roadmap, not just do this, but here's how you need to do this. And then it starts to become a little bit more intuitive when you put your mind in, or put yourself in the shoes of DFAS. But lawyers and litigants and clients and everybody else at that moment in time have their feet squarely in the shoes of the parties and litigants. So I think that's partly why We see stuff kicked back like this. I've seen orders get kicked back because the party's divorce decree date of divorce isn't mentioned in there. And it's, it says, well, it talked about the divorce decree being entered. That information's there. I mean, it's in the whole case file, but only the singular order goes to DFAS. So I think that's where it happens. So let me jump into 3 here. And this ties back to one of those earlier points that we made before about the Former Spouses Protection Act, and the requirement that a court have jurisdiction over the service member if it's going to divide the pension. And the big tripwire being if jurisdiction's based on residency, which outside of a military divorce setting, that's normally the one everybody looks for. They're living in Annapolis. Why, Annapolis is the court to go to. But in a military setting, they may be living in Annapolis because they're stationed at the Naval Academy, but they really, have a residence somewhere else if they weren't at the Naval Academy at that moment on orders. And so not only does the court have to have it, but DFAS is going to reject it. That's Defense Finance and Accounting Service, the people that receive these orders and pay this military retirement pay out. They're going to reject the order if it doesn't say in there from the judge himself, I have jurisdiction and it's based on this. So it would say based on the consent of the parties, based on the domicile of the service member, or based on the residency of the service member for reasons other than military service. DFAS will assume nothing. And if it's not said, then it's going to say, I can't assume and won't accept, just in the absence of a statement, that jurisdiction was appropriate. So that has to be in there. That's a real easy one to just overlook, but it's one that DFAS is going to look at their checkbox, looking for a check in their checkbox.
This seems, with all the conversations we've had, this seems like it's the most nitty-gritty detailed stuff. Like it's all the devil in the details, like, right? It seems like it's all the minutia that I'm seeing. Like you said, a checklist. And if you just miss one little box, it all comes flying back. So this seems like you've got to have a real eagle eye on, or a legal eye maybe, on every single thing. Or it's
where the rubber meets the road. That is for sure. It's where it's all happening right. It all leads up to this. It's like launching the rocket, SpaceX rocket. We're pressing the button now. I hope we did everything right before, and they're checking on it.
And so one little box not being checked means everything can get pushed back. Everything goes right back. It gets delayed, and it costs a lot more money because you pretty much have to start over.
Not the divorce, but start perhaps with this order. And It is a lengthy process. You have to get signed by both parties, submitted to the court signs it, and then you submit it to DFAS and they have 30 days. So it could be a 3-month delay.
Wow.
No, I mean, the worst case scenario is not that you're not going to be paid, most likely, if the divorce is well before the retirement, because it's if, as, and when someone reaches retirement. So it's kind of setting things up for it. Although it's not to say that you couldn't have that pension division post-retirement either, but certainly you just want to get it right the first time because it's going to save you money and time, right? And so a fourth thing that is common, I think this is a fairly common mistake, is a failure to fully and accurately describe the service member's duty history. And that's as of the date of the divorce. So there's something called a frozen benefit rule, which I'll touch on in a little bit. But first, you need to make sure that you've included the pay grade of the service member at the time of the divorce, their number of years of creditable service at the time of the divorce, and then the average of the member's highest 36 months of basic pay at the time of the divorce. So it's also known as the high 3. And because there's this frozen benefit rule, it was enacted in a federal statute. I think it was in 2017 when it was created. But essentially, prior to the frozen benefit rule being in existence, a former spouse was benefiting from the promotions of someone post divorce. So if husband and wife get divorced in 2020 and then husband promotes in 2021 from lieutenant colonel to colonel, and then retires in 2024. Now, 3 years after reaching that promotion, the frozen benefit rule not being in existence would permit that former spouse to get paid the pension at colonel pay, pre-frozen benefit rule. And now with the frozen benefit rule that's in place, it basically freezes the pay grade and credible service and all those things in place at the time of the divorce. So that is when what the calculations will be generated from for the former spouse to know how much of the divisible retired pay will be received because of that. So that's what the frozen benefit rule does. It benefits service members, I would say, because now the former spouse that has been divorced for several years is now not taking from the subsequent years post-divorce. And the key, though, is making sure that all of this information is accurately included in the order so that DFAS knows how to crunch the numbers. Now, it's not to say that you can't. I think also you can probably negotiate around the frozen benefit rule if you were the former spouse through a settlement agreement, but otherwise, the frozen benefit rule is the federal statute in place, and that's how it's applied by DFAS.
Yeah, and as it relates to, they'll calculate the frozen benefit so they can bump it up against the Former Spouses Protection Act, and it acts as a cap. We mentioned in the earlier videos that we did that the Former Spouses Protection Act limits a former spouse, or if there's more than one, all of the former spouses to 50% of the disposable military retired pay, capping it at that. So, you can say negotiate a larger percentage of the pie as of the date of the retirement and effectively get, more than maybe a normal civilian calculation would be. But they'll calculate the frozen benefit rule each time and look for this information in the division order and reject it if it's not. It is always a little surprising to me. It's that we need to give the pay information to the payroll office, for the government, because it's a real task to calculate the high three, and it's you have to really know what you're doing because you're looking at sort of a lot of variables. For instance, every 2 years, a service member's pay goes up, unless I should say that generally it goes up just based on years of service. It also goes up because of cost of living adjustments. And then it goes up because of rank. So you have to know what's the date that we call the pay date. When is somebody going to go over 10 years to now over 12 years? Because that person at certain ranks is going to get more money than at 10, than in that gap of 10 to 12, and so on and so forth. So, but they look for it. They send it right back if it's not in there, and that one's tricky to DIY it, figuring out what the I3 is, in my opinion.
It's sometimes difficult to get that information if you're representing the non-military spouse. You have to rely on the service member to take action to get you the number of points or all the creditable years of service, and sometimes the only way to force that is through discovery. It's not easy sometimes, sadly.
And that one ties back to another. So a lot of this, because like I said, this is everything we're talking about sort of is really, this is the tip of the spear for when it's actually being used. But to Pat's point, the LES will give us everything we need. So if we get any LES, we'll probably get that because it's needed for alimony or child support or just regular division. And the LES is a leave and earnings statement. But what we don't get, and what we really want to make sure we do get in discovery, is that promotion information, because we're simply just asking. And maybe also, not maybe, definitely also, when did they enter the military service the first time? Because it might be they went in and got out and then went back in. So those DD 214s are helpful.
Yeah, it's trickier with a reservist as compared to someone who's active duty, because reservists earn points as opposed to, full years of service because they were a full-time employee. So those things get in the way of an easy solution sometimes.
Yeah. All right. So
I think the one thing that you said, the DIY, do not DIY it. I mean, you said it. You're like, if you're going to DIY, I think what we're trying to make very clear here is this is not the time to do that, if ever, when you're talking about divorce, and especially in a military divorce, because we're talking about nuances here. These are very challenging situations. And you're only talking about 5 terms here. We're only talking about 5. I think you mentioned earlier that there are so many more that have to be considered here. And we're just going on number 5 and
Right.
look at all the moving parts that we're talking about here. So if anybody's getting the message out there, this is incredibly complex and not something they should take on their own with all of this.
I think Mike was the prior session survivor benefit plan.
I think,
yeah. So, I mean, so these things are often, they go hand in hand. The division of the military pension, and then if someone's getting the survivor benefit, which would be, continued pay of that retirement pension post death of the service member. Like, I've seen it so many times. We have current clients having to try to circumvent the federal law that says these things need to be accomplished within a year, and if you don't, you're forever foreclosed. It's just such a huge landmine that if you're trying to DIY things and you can't get it through the right way, and you've now exceeded a year, then maybe you could be out of luck for that survivor benefit plan, as an example, too. So, yeah.
It's such a minefield that some lawyers will put in a retainer agreement that I will do everything up to the final judgment of absolute divorce, but I don't do any of the post-judgment work. And I'll say that's even true of us. We'll do military pension orders, SBP, and TSP because it's military member have those 3 benefits. But if it's a state board of education pension order or, some other 401k division, we don't get involved because it's a totally separate, different set of federal statutes, because it really relates to taxes for non-military. If you don't do it right, then it may either not transfer or transfer with a huge tax and penalty because you didn't check all the boxes to make it a tax deferred transfer, subject to based on a divorce. So we swim in the lane that we know very well. A lot of lawyers stay out of all of the post-judgment lanes when it comes to these orders because they are all so hyper-technical and based on federal, more likely not federal, but also some state statutes in the case of, for instance, education divisions, orders and so forth, Department of Education, I guess. All right, so let me jump into number 5 here real quick. And this is kind of where it really does, it gets case specific and where DFAS really does need to make sure they understand it. If there's any bit of ambiguity, they send it right back because they say we can't assume anything. And this is the statement that says, okay, here's what the former spouse gets, from the service member's pension. And you can imagine if you're the service member, you don't want them guessing or assuming anything, right? And that's the tack they say. They say if we have to guess or we have to assume or there's a missing piece of information as to this, start over. There are four ways that they will, four approaches that they're willing to accept. Either a fixed amount, where you say, hey, listen, DFAS, give former spouse $500 of the military retired pay, period. That's the easiest way, right? That's the least desirable way because, if the cost of living and everything goes up, then it's still $500. You can write maybe some changes to that, but default is going to be it's $500. You could do a percentage of the retired pay. So you say, give 40% of the military retired pay. Okay. Now that's going to be based on the frozen benefit rule, 40% as of the day of the divorce by default and automatically. But as it continues to go up, or if for some reason it went down from that point, the percentage remains the same. You can do a formula. And most of the time, a formula, or very frequently, a formula is used to say, we don't want to divide the whole pension. We want to divide the marital share. So the formula would be the number of months of marriage overlapping. So let's say if it's 10 years of marriage over the total years of military service, and let's say that ends up being 20, that gives us 50%. And they'd say, of that 50%, here's what the wife gets. Maybe it's 50% of that. So in other words, 25%. But you have to clearly set out that order in terms that there's no dispute. For the 10 years for the wife, you'd say, or the former spouse, you'd say the overlapping period of the marriage and the military service, which is 120 months. You have to state 120 months. And then whatever, you can leave open the variable of how long the military service is because you don't know that oftentimes if the member's still serving. But DFAS knows that information and they don't have to guess on it. They just look at their records. And the last one is a hypothetical. And these are hard to write. And these require an understanding of what you're doing and what they need. And this would be one maybe where you say 50% of the military retired pay, if the service member hypothetically was to retire with 10 years of military service as of the date of the divorce and with a high 3, so the average pay of X dollars. You have to have all of those variables in there so they can just say, okay, well, 10 years based on this retirement plan, and the most common one is 2.5% a year, would be 25%. We give the high 3, so they'd say 25% of that high 3. We now know the hypothetical retired pay, and then they would be able to say, how much did they say that they get of that? Oh, 50%. Great, 50%. Now they have that number. So this one's very complicated, but those are the 4 ways that they will accept as long as they don't have to guess or assume anything about what you were describing right there.
Wow. Well, you certainly left the 5th one to be the most moving parts out of all of it, Mike.
Yeah.
Yeah, you just said a lot of words.
I just crammed in 4 more to our 5.
I think you did. Because that was complicated, but I think it goes back to why we do this live stream, why we're creating, this resource, because I think it conveys the fact that this is a complex situation this is only one part of a military divorce, and why you need specialists like yourself to put these moving parts together. Because what you just said right there, I know you were following along quite a bit, but I was trying to keep track.
It was making my head hurt also listening to it. So.
Well,
yeah.
It's a great way to, we're coming down to, the final stretch of our 30 minutes here. And it always goes by so fast because you drop such great information, both of you. And I have to say thank you. But when people go back and watch the replay and watch this video, there's such great information here. And And you have to understand that this is complex, and that's why we do it. We do it for people. So thank you so much, Mike. But my head is spinning on that one. I just want to let you know.
Sorry, makes my head hurt too. Well, there are some additional resources. So one of the things I'd say is go to DFAS. Have your lawyer. If you have a lawyer you're working with, have your lawyer go to DFAS and familiarize themselves, because they'll say to you, DFAS website will say, we need to have these things in it. If not, we can't accept it. We'll return it. And so I don't think it's totally comprehensive. It's not sort of paint by colors, but DFAS has really good information on its website, and it has a template. So to help somebody know how to draft a hypothetical, because it has some sample language in there. And then I guess I should also, with all that, also raise the disclaimer sort of piece to this, that we've really been saying, and it's so true, that the possible avenues and check boxes that are needed in any given case are highly variable. Somebody who's retired, somebody who's active at the time of divorce, somebody who's a reservist versus somebody who's active duty, somebody that has a disability retirement versus a longevity retirement. All these things are variables that we didn't touch on, and really probably would just be too confusing. It's sort of, you just need somebody to help map out your situation rather than try to explain all situations. So really, as we've mentioned in the past, we recommend that anybody who needs a military pension division order engage with their attorney. If their attorney can do it, great. If their attorney can't, to reach out to, and there's several attorneys across the state, across the nation, that can do this, and really get the right people helping prepare something like this, because this isn't an area that makes sense to do it on a wing and a prayer.
Absolutely. And of course, if those of you out there would like to talk with Mike or Pat or anybody at Patriots Law Group, you could certainly go to patriotslawgroup.com and reach out to them. You also could look at a ton of additional resources that they offer on their website, things like this, as well as various blogs. And you'll find a ton of resources to help you navigate your military divorce, as well as other legal issues that you may be having. But we want to thank everybody for tuning in today. And for those of you who are watching the replay, we thank you so much and hope you find this information valuable. We will be back in a few weeks. We are here the second and fourth Wednesday of every single month, and we really hope you found this information valuable. Please reach out if you have any questions, and hope to see you in a couple weeks with another great topic, again, to help you navigate the challenges of a military divorce. Thank you so much. See you soon.